Hello, everyone. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everyone. And in today's session, we are diving into contract law 2, and we are going to see vitiating factors that are factors or elements that can vitiate a contract. To vitiate a contract means to render it void or voidable. So it alters the validity of the contract. It affects the validity of the contract. That is what we call a vitiating factor. And among the vitiating factors that we are seeing this semester, we shall look at today, especially uh, mistake in law of contract. So, without further indulgence, I'm Counsel Ben, and let's jump right in. So, the first thing we have to know about mistake is that the definition of mistake, and we shall define it with authority according to the Merriam-Webster Dictionary, 8th edition, published in 2002, that mistake means a misunderstanding of a, a misunderstanding of the key terms of the contract, or a mistaken belief about the material the material fact of the contract or the subject matter of the contract. So it's a misunderstanding of the key terms of the contract and a mistaken belief of the material or the subject matter of the contract. That is what we mean by mistake. And we shall go on to see the types of mistake. Generally, we have two types of mistake. However, in some books and some lecturers can tell us that we have three types of mistake because two of them can be resumed in only one. So there is bilateral mistake and unilateral mistake. Then in bilateral mistake, we have two types of bilateral mistake, that we have common mistake and mutual mistake. And we shall start with common mistake. Common mistake is a mistake or is a situation whereby two parties to a contract are mistaken on the same material facts, on the same subject matter of the contract. They have the same wrong belief in the contract. So when they are both mistaken about the contract, that is what we call common mistake. And in common mistake, we shall have two instances. Yeah, we shall also have two instances in common mistake, and we shall have res extincta and res sua. And speaking about res extincta, it's in Latin. That means the thing that has been extinguished. This is just simply to mean that the subject matter of the contract is not existing at the time of contracting. And in this matter, we shall see that when the subject matter of the contract is not existing even at the time of the contract, so what's the place of the contract? The contract does not have place, so it renders it voids ab initio. And that also we see that mistake is provided for in the Contract Act Cap 284 of the Republic of Uganda under section 16 and 17. 16 providing for mistake of facts and 17 providing for mistake of law. But mistake of law is more advanced in contract law. So we were talking about res extincta. And res extincta, we see that the subject matter of the contract does not exist at the time of contracting. Uh, Let me give an example, a just simple example or a scenario to make us understand very well. Let's say we are contracting, me and you, that I have my land somewhere, and we are getting into a sale agreement. We agree that I'm going to give it to you. Then, okay, not land, but let's say something that is movable. Let's say I have my car somewhere, and we are going into a sale agreement, and I'm telling you that yeah, I can give it to you at this price. So we contract and we sign actually, but at the time of contracting, we didn't know that maybe when it was at the parking, a fire broke out and it got burned. So At the time of contracting, the subject matter of the contract was not in existence. That is what we call res extincta. The famous case here is Hasti versus Couturier, whereby the two parties entered into a contract to to it was a sale contract for corns, shipping them. However, along the way, uh, due to due to weather and heat on the way, the the corn got spoiled, and getting spoiled, they were obliged to give them out. So the corn never reached at the destination. So they contracted when the corn were still in on their way, and they had already got spoiled. So at the time of contracting, Hasty and Couturier were both in common mistake that we call res extincta. The same happened in Galloway versus Galloway, where a couple who thought that they were married, they tried to go into a divorce agreement. Divorce agreement is a contract. So since they wanted to go into that contract, they didn't know that the first wife of the man was still alive, and since she was still alive, their marriage, the marriage of the second wife and the husband was not valid in law. And since it was not valid, there was no marriage. So uh, the here in this case, marriage is the subject matter of the contract, and since marriage is not there, it's res extincta. At the time of the contract, the subject matter of the contract does not exist. Let's go into the second type of common mistake, that is res sua. Res sua simply means that in from Latin, literally translated from Latin, it means your own thing, or my own thing, or his own thing. So it means that here the owner of a thing is purchasing his own thing. The owner of, let's say, a car comes and pays for it consideration to get it. So I think it's self-explanatory when you have both of you are mistaken, because it's still under bilateral mistake where both parties are mistaken. But here we have now common mistake in bilateral mistake. So both parties are mistaken about the ownership of the material, the material, the subject matter of the contract. And here, in the case of Cooper versus Phoebes, Cooper and Phoebes never knew that the uncle of Cooper, before dying, in his will, leads. Okay, yeah, he he gave out his salmon fishery to Mr. Cooper, and Cooper continued paying rent in the salmon fishery, though in the will it was already his. So when he discovered, the court held that he could no longer be paying, and that contract, he could not enforce that contract, since uh, they were both under mistake, and that is common mistake under res sua. Let's now dive into mutual mistake as the second type of bilateral mistake. Mutual mistake simply means that both parties are mistaken, but at cross purposes. They are not mistaken about the same material facts of the contract, but they are both mistaken, yes, but at cross purposes. They're not mistaken about the same thing. Let's say I have two phones. I have an iPhone, let's say, and a Samsung, and I just come to you and I tell you I'm selling a phone, and for you, and you ask me how much, and I tell you just maybe 5K. And for you, in your mind, you know that you are buying the iPhone, though for me, I know I'm selling the Samsung. So you see how we can be mistaken at cross purposes. We were not really mistaken about the same thing, but we were mistaken at cross purposes about some slightly different things in the contract. And that is how mutual mistake arises. A case of mutual mistake, we have the case of which Raffles versus Witcheless. And in that case, Uh, there were okay. A ship called PLS was supposed to bring to ship some goods from Liverpool, from Jamaica to Liverpool. However, there were two ships called PLS, and one was moving in 1 month, and the other was the one was moving in November, and what the other was moving in December. So when Mr. Wichelas and Raffles contracted, they were mistaken at cross purposes, since one was referring to one ship, and the other and yeah, the other party was referring to the other ship. So their minds never met. There was not consensus ad idem. Consensus ad idem from Latin means minds meeting, or mm, to to have a same agreement on something, because idem means something, consensus comes from consent actually. So they didn't consent to the same thing. And you know that in contract law, the most important thing is to consent to a same thing, because contract, as defined under section 9 of the Contract Act, is an agreement between two. So there was not agreement, since their mind never met. And that is how we see the principles in mutual mistake. Let's now go to the second big type of mistake, that is unilateral, because we have exhausted bilateral, when we saw that in bilateral both parties are mistaken, and in bilateral we had common mistake and mutual mistake, and then we leave bilateral to go now to unilateral. And I think it's self-explanatory, even from the name of it. We see that unilateral is a mistake whereby only one person in the contract is mistaken, the other one is not mistaken. So when only one person is mistaken about the subject matter in the contract, that is what when we occurs yeah that is when occurs uh, unilateral mistake. And here it has also some instances where it occurs. For example, when there is a mistake as to the identity of the person with whom you are contracting, you might let's say you might have the intention of contracting with someone very important, and I impersonate him. I come as him. Let's say, take an example. They tell you that, yeah, this member of the parliament wants to buy goods from you, and for you, you know that, yeah, I would like to sell my, let's say you have a stock of funds, my funds, to this member of the parliament, because you know that it's some good relationship you are creating with him. But later on you discover that it was not even like the one who was pretending to be a member of parliament was not even an MP. So there you were mistaken about the identity of the person with whom you were contracting. And that is what we call the first instance of unilateral mistake, that is mistake as to the identity of the person contracting. Second instance, before first I go to the first instance, the case on this one is Candy vs. Lindsley. I urge you to go and look for that case. It's really an interesting case, and it will really be helpful when you're answering for your papers. The second instance is where a party is mistaken about the subject matter of the contract, but only one person. Let's say we are we are making a sale agreement, and we are selling mm, uh, anything, phones, pens. But for you, you thought maybe we were selling phones, uh, since you saw, let's say, the logo of iPhone, the logo of Apple on one of our products. You thought maybe we are selling iPhones. Then when you came and you contracted with us, but Later on, you discover that they are not even selling iPhones. So that is how it comes. The third one the third instance in unilateral mistake will be the mistake as to the terms of the contract. Mistake as to the terms of the contract. When someone understood the the terms of the contract in a wrong way, but the other one got them in the perfect way. That is also one of the instances where unilateral mistake can occur. Uh, that is all when it comes to mistake in contract law. I hope you've really liked the video. I urge you to like, to subscribe, and to share the video. And it's still under Agora Legis with Council Ben. Thank you for watching.